Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam. And before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information shared, including user comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, friends, after this very important disclaimer, we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. And don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. With that, folks, today we are here with another very exciting and very important topic because H1B season is here. And if I'll ask you a question that are you fully prepared for the H1B lottery 2025? Then I'm sure you're not confident enough to say yes. But after the show, I'm sure you will be. Because today we are going to explore a very timely topic that about H1B registration system that is recently a very new change has come up over there. What it is, how is it going to increase your chance for the lottery system in 2025, and also how is it going to impact everyone, the employer, the employee, and what will be the outcome for that. We are going to have a great discussion on this webinar. And to help me out and to make this session even a wonderful one, we have a very special guest with whom we have shows on every Wednesday at 12 p.m. A very well known expert in immigration law, Attorney Prashanthi Reddy from the law offices of Prashanthi Reddy. So, thank you so much, Prashanthi, for being here. And it's our first time that we are connecting together and having a show together. And I'm really excited. So, thank you so much for being here.
You're welcome, and I'm looking forward to this show.
Absolutely. It will be wonderful as your every shows go with. All right. So, Prashanti, before diving into our questions, that we have prepared, I would also like you to let us know so that, our viewers can get a better understanding about the change that happened in the H1B registration system.
So, I guess just to give you a background about what to expect this year with the H-1B registration system, the biggest change is that the registration is now $215. It was $10 earlier, so that's a big change. The registration fee has gone up. We were expecting that last year, but by the time the law was actually passed, it didn't come into effect last year, but we knew that it would come into effect this year. So that's the biggest change. The registration fee is now $215 as opposed to $10. In addition to that, we've seen some changes that took place last year as well, and that will continue to this year. Those changes are that we see a new account, an organizational account, which is in place for you to do your registrations. That organizational account is updated. It allows multiple people to log in at the same time. It allows you to prepare your registration seamlessly, allows you to check for duplicates. So this is a new system, the organizational system, which was not there the year before. It was there last year, but not the year before. In addition to that, last year we saw that a huge change, which was that they made the registration system beneficiary centric, which means that no matter how many registrations you file as a beneficiary, you will get only one pick in the lottery based on your passport ID. So even if you file duplicate registrations through different employers, you don't get a better chance of being picked in the lottery. You have the same chance of being picked because it's only one. You get only one entry into the lottery, no matter how many registrations you've done. So that's a huge change as well. And of course, this year, we will see changes in the H-1B process itself. But I think with reference to the registration, these are the changes that we can expect.
All right. Okay. So I think this is the brief that our viewers are getting to know today about the latest changes that happened in H1B registration system. Also, Prashanti, as you mentioned some changes, I would also like to know about this, I would say, the beneficiary centric topic. Because earlier, what used to happen if three companies have registered, I mean, three companies can register the same individual, right? And that same individual have more chances to get selected as compared to the others who only had one chance with a single registration. So don't you think the person who got chances, three companies getting registration from those three companies are better performing as compared to the other one? So don't you think this is, I mean, do you think is it really going to make the system fair enough?
I think so because what was happening is our people, people tend to game the system. So the more leeway you give, the more opportunity you give, the more likely it is to be misused. And that's what happened last year.
Okay.
I mean, the year before, we saw 780 uh, thousand registrations, right?
Mm-hmm.
And there's only 85,000 H1B numbers. So, and that we saw like 400,000 of them were duplicate. Like more than half of the registrations were duplicate. And we also heard reports of one person filing 100 registrations,
Oh.
150 registrations
Mm-hmm.
to, so trying to game the system.
Yeah.
So it's not, I can't believe that one person had 150 job offers.
Absolutely.
So it's more likely that there was collusion,
Mm-hmm.
which means that, um, sister companies, so companies are colluding with each other to file the registration for the same person, um, resulting in, them getting one of the companies getting picked and then the company sharing the profits, etc. So this was called collusion. This is not allowed even now. It's not was not allowed earlier. But of
Mm-hmm.
course, when if it's an independent job offer, one beneficiary can file more than one registration
Okay.
as long as the job is different for each employer and
Mm-hmm.
there is no relationship or no collusion between the companies. But of course, now with the beneficiary centric system, there is no longer an incentive for the beneficiaries to file more than one registration. They're still doing it because they're not sure that that one company will, file their H1 even if they get picked. So they're just to make sure that they have a backup. Maybe beneficiaries are still doing more than one registration, but they're definitely not doing 100 registrations. So I think this was needed for the registration system to remain intact.
Mm-hmm.
Otherwise, they would have to remove the registration system because it was not working. So
Yeah.
to protect the integrity of the registration system, they came up with the beneficiary centric selection process, which I think was key if they wanted the registration system to work moving forward.
Mm-hmm.
So we didn't really have any choice because of how the system was being used. How will this impact companies that previously submitted multiple registrations for the same candidate? Um, so multiple registrations were not allowed at any point of time, right? So if you file multiple registrations for the same candidate, then most probably you are not picked in the lottery. You are not even included in the lottery process because they reject the registration as soon as they find the duplicate.
Oh.
So if you filed by mistake even for this beneficiary twice from the same company, then immediately your registration itself does not get submitted. It gets into a rejected status due to duplicates. So it will not even be put into the registration. So that's what happens if you file multiple registration for the same candidate. Now, on the other hand, if you collude with some other company, maybe USCIS will not come to know during the registration process, but I've seen RFEs even for last year's registration, even though it was beneficiary centric, people did still colluded. I don't know why, because there's no usefulness in it anymore. But maybe out of old habits or by mistake, there was still collusion, and USCIS still sent notice of intent to revoke and finally revoked those cases or sent an RFE asking for an explanation. So don't do it, even though there's no usefulness in doing it. I don't know why companies are persisting in continuing to do collusion.
All right. I think that's wonderfully explained. And I was about to ask how is it going to impact the different companies and different also how is it going to impact. But you already answered that. So thank you so much, Prashanti, for making us understand this whole change and also the impact in a very simple way. And with that, I have another question for you, Prashanti, that the new beneficiary centric selection process aims to reduce the duplicate registration. That's what you said right now. So now I would like to know how does this affect the candidates with multiple job offers?
So it shouldn't affect the candidates with multiple job offers. If they still want to file, several registrations, they can. And whichever registration, I mean, it'll only be one chance at the lottery. And then
Mhm.
if they get picked in the lottery, then they can decide which H1 that they want to go with, which company they want to go with. So that's how it works now. If you have filed for several companies, then you can choose which company that you want to file the H1 with. So it becomes up to the beneficiary to choose. Of course, you can't file more than, I mean, you can even file more than one H1 and then decide which H1 you finally want to take and withdraw the other one. But there's only one lottery, one number that goes into the lottery system. And if you get picked, if you have several job offers, you can choose to file the H1 with all of them, or you can choose which ones you want to file the H1 with. But finally, you're allowed, you obviously will work only for one company unless you're filing concurrent H1s. And then in which case, then it does not have to be, it's not subject to the cap because a concurrent H1 is cap exempt. So you would, under the cap, work for only one employer and you choose which employer you want to work with.
All right. Okay. And here's another question, Prashanti, that USCIS has indicated a stricter oversight on fraud and misuse in the H-1B lottery. And so, what additional documentation should employers and applicants prepare to avoid these issues?
So, yeah, I mean, under the Trump administration, they are focused on combating fraud and abuse of the H-1B visa program, and even previous administrations did. But the present administration seems to be of the opinion that there's a shortage of qualified workers, that the H-1B is to, target the shortage of qualified
Mhm.
workers in the country. So if there is a shortage, then the H-1B program is useful. But they seem to think that there are a lot of American workers who are qualified, willing and deserving to work in these fields, but they're being ignored or unfairly disadvantaged
Mhm.
due to, because of the H-1B program. So to start off with, USCIS has come up with a statement that they think that the H-1B program is not important and is not as useful as it was meant to be. So starting off with that, if you start off with that angle, then obviously you see that they're going to discourage people from filing H1s, and they're going to uh, try not to approve cases, and there's going to be extreme vetting on H1s because their mindset itself has changed. The present administration's mindset has changed.
Mhm.
So what they're basically saying that employers who abuse this H1B visa program, they are negatively impacting the US workers. And so in order to combat fraud, they want, um, you know, anyone who reports this kind of H1B fraud. So if you're an employee and you report the fraud that your employer is doing, they want to make sure that there is some option for you to remain in status because your H1B will then be withdrawn by the employer. So they are trying to find some protections to help those H1B workers by allowing them to extend their H1 status or change to another immigrant status, under the extraordinary circumstances rule, which has always been there. It's like a catch-all phrase which allows people to go back into status once they're out of status, provided USCIS agrees. So it's a nunc-pro-tunc petition that has to be filed under humanitarian grounds. Or extraordinary circumstances, they approve these cases. So what kind of H-1B fraud and abuse indicators are they going to be looking at? And they've given some indicators in their latest press release.
Mm-hmm.
H-1B worker is not or will not be paid the wages certified in the LCA. So if you're not being paid the prevailing wage, there's a wage disparity between the H-1B workers and other workers performing similar jobs to the detriment of the US workers, meaning the H-1B worker is being paid more than your other, say, US citizen workers for the same job. That is abuse.
Yeah.
H-1B worker is not performing the duties as listed in the H-1B petition. Uh, then the H-1B worker has less experience than a US worker that you're hiring for a similar position. So they're making sure that there is no unfair advantage to your US worker and you're not giving any um, advantage to the H-1B worker as opposed to the US worker. So with reference to wage, with reference to hiring someone with less experience, and also the H-1B worker is not working in the intended location where they're supposed to be working, then it's also abuse. So they've, listed a few um, examples of where H-1B fraud or abuse would be found. And they
Mm-hmm.
have increased H-1B site visits. Starting, they said, as of January, they've increased those site visits. And so that is how they're also kind of preventing fraud or vetting, doing extreme vetting on H-1B employers, especially consulting companies. So they're doing more vetting, or they have said that they're going to do more site visits for H-1B dependent employers, that is your consulting companies who have a high ratio of H-1B workers as compared to other US workers. Cases where they cannot validate the employer's basic business information through commercially available data. So if they can't find your company on, they can't find a website for you, they search and they can't find you on their Vibe database, then most probably they'll do a site visit. So important for employers to be part of the Dun and Bradstreet employer database because that's where they get their Vibe information from. Also, employers petitioning H-1B workers who work for other companies offsite. So we're talking about the consulting company scenario. So they're going to be increasing or expanding site visit for consulting companies as well. So this is what they're doing. They're targeting site visits for these kind of companies. They're trying to they're kind of giving you a list of what who will be a H-1B fraud or what will be a H-1B fraud, and they're seeking to protect US workers in this way.
That's right. And I think that's a good step. They can only try these steps and these changes to protect the US workers. After all, we have been seeing a lot of misuse and lots of abuse that's happening in the system. But I think absolutely that's how they can make the system work fairer and also more flexible. So with that,
Which,
Prashanti.
which Sam would be a good thing if it was just being done for the purposes of being fairer and flexible. I agree with that, and everybody does, I think. But I think the reason that they're doing this is to prevent even companies that uh, do H1s properly, prevent them from filing H1s or creating a fear in their minds
Yeah.
in order to not to file H1s. So I think it also creates fear uh, and prevents even those people who are actually doing using the system properly from using it and filing H1s,
Yeah.
in my opinion.
I think that's a wonderful opinion because that's what President Trump's administration has also come up with, by deporting so many people back to their home country. And that's how they are setting an example that they are not going to tolerate any illegal immigrants and any abusing things that may destroy the immigration system. So that's the main agenda, to create the fear in every illegal, I would say, not only immigrants, but also the frauds, the scammers, and especially the agents, those who are promoting these H-1B, fraud things. So I think,
Which again, Sam, is fine if they are only targeting people who are not following the law. But I'm just hoping that they don't target people who also follow the law by making the law harder than it actually is. For example, if they're sending out RFEs and they're asking for contracts for all 3 years, if you're
yeah.
filing a H1 for 3 years and asking for contracts for 3 years, then that's not in the law. But there's still USCIS is still, if they still ask for it like they did under the previous administration, then that is not fair. Then you're shutting down the H1B system or finding ways of shutting down the H1B system. No one is complaining about uh, cracking down on fraud because that is extremely important. But in the guise of cracking down on fraud, don't shut down the entire H1B system or make it more difficult for people who qualify to apply for a H1. That's my point.
I'm loving your point. Yeah, absolutely. That's very well said. If we are seeing one side is growing, then another side is also bringing up more challenges. But I think, Prashanti, that is why we are here to make our viewers aware about the new changes and how they can also protect themselves under, I would say, a very tough time that's happening right now in 2025. And the great thing is that our viewers are really engaging with us, and I can see a lot of viewers who have joined us. So let me take some comments. I can see Vishwanathan is here. So he's asking a question that got my L1 I 129 approved with work location as a NJ office, but today got an additional client option from another city in TX. I will manage both, but which state can I reside? NJ as per petition or TX? Yeah.
Well, if it's an L1B petition, um, it's not like it's not the same criteria that they use for the H1, where the work site is mentioned in an LCA. There's no LCA, so it's not as important as in a H1 where your prevailing wage is based on your work location. The LCA mentions the work location. Your I-129 mentions the work location. So if you don't work at that work location, then you are violating your status. In the L1B scenario, which I think maybe that's what it is, because you just say L1, you don't say L1B or L1A. The work location is important in the sense that they want to make sure that you have a bona fide job offer, which you've mentioned in the L1. So you want to make sure that there's no fraud there, but that is the extent to which the work location is important. But I would say still stick to New Jersey uh, location because that's what has been said in your L1.
All right. So I think Vishwanathan, thank you so much for being here and participating in this webinar. Let us know if you still have any follow-up question or would like to uh, know any other topic about today's webinar. We would love to hear from you. And let's take Prateek's question also. I got selected in last year's lottery, but my application was denied due to a specialty occupation issue. If my employer registers me again this year, will my denial from last year impact my chances?
No, but you have to learn from your mistakes, right? So if you used a particular job title last year and USCI said it was not a specialty occupation, it's likely that you'll have the same problem this year. But if it's with a different employer, um, but there's another problem there. If it's the same employer and now they're using a different job title, USCIS might question what the job title actually is and whether they're making that change just to circumvent the specialty occupation issue. But if you're filing through a completely different employer, then of course, the previous issue will not impact you as long as you're using a different job title.
All right. So Prateek, please let us know, is it the same employer or the different employer, so that we can have a more conversation into that and can really help you out in your problem. So thank you so much, Prashanti, also for answering Prateek's comment. And let me take Kritika's question. I'm outside the US and my employer wants to register me for the lottery. If I get selected, how does my visa stamping process work? I am hearing delays in consulates. Could I get stuck for months waiting for an interview?
Well, if you're outside the country, you're already, you're not waiting for anything. You're just living your life, right? So if you do get picked for the lottery, which there's a 30% chance of that happening, um, I mean, yes, there could be a delay in visa processing. Your visa could get denied. H1 could get denied. Anything can happen between the time that you file the registration and after that. So I would say don't give up your job right just yet. Wait to actually get the visa stamped. Then, if you're working somewhere, then you do the resignation, because there's so many things that can happen in between. And yes, you're absolutely right. There could be delays, and uh, the visa processing under Trump is also will you will experience again more vetting. They are asking for client letters, etc. So that could cause delays due to administrative processing um, happening. So yes, you couldn't, or nothing, or your visa might just get approved, very quickly. We can't say. So I'm just saying, be prepared for the worst, so that you will not be caught by surprise.
That's right. Okay, thank you, Kritika, for asking this question. And let's take Supriya's comment. I'm currently working on OPT, and my employer is sponsoring me for the H1B lottery this year. But I'm worried if I don't get selected, what are my options? Should I plan for day one CPT, or is there any other way to stay in status?
Unfortunately, no. A lot of students face the same predicament, as there's only a 30% or 25% chance of getting selected in the lottery, and there's no duplicate. And there's no point in filing duplicate registrations anymore, so you can't increase your chances. But your chances kind of are increased if you are a master's degree holder from the US. So that will improve your chances, because then you have two picks in the lottery, one under the master's cap and then the other under the bachelor's cap. So hope for the best, but if you don't get selected, then you have to continue your F1 student status, or you move to a different status. But there is no other work status that you can move to if you're an Indian national. You could file a green card, but again, the green card numbers are not available, so there's no purpose in doing that. So I don't see many options for you. Um, you could try for a J1, but again, J1 is not available for all jobs, and it's complicated, and you might need a waiver, etc. So I think the best option would be an OPT if you're an Indian national, um, if you want to continue working.
All right. So, thank you, Prashanti, for putting these very important pointers with us. And Supriya, if you still have any follow up question or would like to know more about it, then why don't you go ahead and contact Attorney Prashanti Reddy directly to her contact number? And it's not only Supriya, I would say that everyone, the friends, those who are watching us, whether it is Vishwanathan, Kritika, or anyone, Prateek, please go ahead and give a call to Attorney Prashanti Reddy, because it's really high time. And taking decisions, not relying in a very credible source, is really going to make your visa process more complicated. So to smoothing it, I would suggest to take expert advice. And the contact details are on the screen. That is 212-354-1010, with the email ID prashanti at reddyesq.com, and the website is www.reddyesq.com. So, with that, friends, we have completed our first session of this webinar. But, Prashanti, I think now it's time for us to take a quick break so that we can get more engagement from our audience. So, friends, don't go anywhere. We'll be coming up with more insightful answers from Attorney Prashanti Reddy. And go ahead, put up more questions as possible. And we are here for an half an hour more. So thank you everyone for joining us. Keep watching Immigration Talk Show. We'll be right back. Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam, and today we are having a great discussion on the topic H1B season is here. Are you fully prepared for 2025 lottery? And today we are having really wonderful insights from none other than Attorney Prashanthi Reddy. And till now, we have covered a lot of different perspective into this conversation. But with that, Prashanthi, I would like to go ahead with my very next question. And this is about increased scrutiny on employer-employee relationship. So, how could employers structure contracts and work arrangements to align with USCIS expectations?
I hope that there will not be increased scrutiny on employer-employee relationship. As per the new H-1B regulation, they're certainly moved away from the employer-employee relationship issue. The only thing that they want to see now is whether you have a bona fide job offer for the person that you're hiring or not. Um, so I don't think employer-employee relationship is an issue unless USCIS somehow makes it an issue by filing a new regulation. But as of now, it's not an issue. So the only thing we need to worry about with reference to contracts and work arrangements is whether they show that there's a bona fide job offer or not. And for that reason, we might have to submit them, but not for the employer-employee relationship issue.
All right. Okay. I think that's a good news. And also, Prashanti, my next question is that there are reports that USCIS may prioritize wage levels in future lotteries. So, while this hasn't been implemented yet, do you think that it will impact the fiscal year 2025 selection process?
No, because the registration process for 2025 um, for the 2026 fiscal year is still based on the lottery system. It's a random selection process. It's not being based on wage levels. Of course, the Trump administration has said, in pending Judiciary Committee bill, that they want to use either an auction system or prioritize people who have higher wages for the lottery. But they haven't. That is only a proposal. We're waiting for the bill to be formalized, introduced. Nothing has happened yet. They've said that that might be introduced in March, but that's too late to affect this registration this year, because the registration is already starting on March 7th
Yeah.
and ending on the 24th. So it's unlikely that that will affect this year's registration process.
Okay. All right. That's great. And also, Prashanti, if you let us know what are the key differences in how USCIS is assessing specialty occupation roles this year as compared to the previous year.
So there's a new H-1B regulation in place which talks about a couple of things about specialty occupation. It's not a major change because the regulation basically says that it's reconfirming what USCIS has been practicing in the past few years. But what they've said is that number one, the specialty occupation, the job should be directly related to the major. But they've also said that the job doesn't have to require just one major, it can require a range of majors as long as each major is related to the job. So, what is a specialty occupation? A specialty occupation is an occupation which requires a bachelor's degree in a specific field. And how do they know if a bachelor's degree in a specific field is required? Of course, they look at the industry, they look at Google, they look at uh, a website called the Occupational Outlook Handbook, which is published by the Labor Department every year. And that has positions and it shows what is the educational qualification for the position. So usually USCIS will look at that and they'll say, okay, software engineer, as per the Occupational Outlook Handbook, requires a bachelor's degree in math, physics, computer science. So it's many majors, right? So we have to show that each of the majors is related to the position to show that it's a specialty occupation. So it has to be directly related, and if there's more than one major, you have to show that every major is somehow related to the job description. So it's useful to have a table to show, how it's related. So that's two things that have changed. I mean, which have not really changed, but they've clarified it. The third thing they're saying is that, and again, they're clarifying this, is that even if the for example, occupational outlook handbook says that um, always, I mean, mostly a bachelor's degree in computer science is required for this position, but some employers don't require a bachelor's degree. This can still be considered to be a specialty occupation because it doesn't have to be always, it has to be most of the time. So they have clarified that because in the past they were denying cases based on these points, based on there not being one major, based on the fact that all employers don't require it, only some employers require it. So this is in a way good for H1Bs, but it can be twisted and used in a different way by the present USCIS administration to also deny cases and make it stricter. So it all goes based on interpretation, right? How you interpret the regulation. So they can interpret it differently. So that's about specialty occupation and how things have been clarified in the present regulation.
All right. I think that's wonderfully explained the difference between the two. And with that, Prashanti, we have another viewer. Vishwanathan is back again with another question. So I would like to take his comment. Vishwanathan is asking that L1A managerial role petition as NJ office work locations. Can I file amendment to the petition from NJ to remote?
I don't think it really matters whether you're working remote or in the office in a managerial role. I don't think for L1A that is really important. They don't care whether you're working in person or remote as long as you're working. Uh, but I think it's a good idea to live in New Jersey so that not too many questions are asked when you file your extension. But otherwise, I don't think it matters that you're working remote. It depends on what your office wants you to do or what your office procedures are, processes are with reference to working remote.
That's right. I think this is the question that Prashanti, most of our viewers have, regarding working from office or working from remote. But actually doesn't matter, right? For the
That's only
L1.
for L1. Only for the L1, it may not matter, but for a H1, it definitely matters.
All right, all right. Okay. Thanks for clarifying that. And I can see a similar question from Samuel's side. I work remotely for a US company while living in Canada. They want to sponsor my H1B this year so I can move to the US. If I get selected, will I need to be in the US for the petition approval or can I do everything from Canada?
You can do everything from Canada. You can apply for consular processing, and then once your H1 gets approved, selected and then approved, then you can go for a visa. You can go in Canada your closest U.S. consulate and get a visa, and then come into the U.S. on a H1 visa, and then start working in the U.S.
All right. Okay. Thank you, Prashanti, for taking these questions up and also answering them in a very great way, in a very detailed way. Rekha is here, and Rekha is asking I work for a small startup, and they are sponsoring me for the H1B, but they don't have an in house immigration team, and I'm worried they might miss something. What are the biggest mistakes startups make in the process, and how can I make sure that everything goes smoothly?
Well, they don't need to have a in-house immigration team, but they do need to have an immigration attorney. So as long as they're using an immigration attorney, I don't think there is an issue. The attorney will take care of everything. But in general, for a startup, the problems that they face is maybe they don't have physical offices yet. So make sure they have a physical office. Make sure that they're able to show that they have a job available for you. Make sure they use a proper job title, proper job description, which shows that it's a specialty occupation, pay the prevailing wage, after the H1 gets approved, work from the location as mentioned in the LCA. So these are the things that have to be done,
Yeah.
before filing and also once your H1 gets approved.
That's right. Well, Rekha, we don't know whether they have the immigration attorney or not, but we definitely have. And we have one of the finest immigration attorneys. So please go ahead and reach out to Attorney Prashanthi Reddy. The contact details are displayed on the screen. So go ahead, dial the number, call her. You can also email her and surely visit her website. So that would be great. And with that, I think I have covered all the comments that we got from our viewers. So now, Prashanti, I would like to shift our focus to our Facebook question. So, with your permission, I would like to reach out to Facebook question. Will that be okay?
Sure, sure, go ahead.
All right. Before Facebook question, Prashanti, this is the comment that we got from our viewer on YouTube. So he's asking that my girlfriend has her B1 B2 visa appointments in 2 weeks from now. We have all documents completed except for the travel health insurance. Does she have a better chance of being approved for the visa having the insurance, or it makes no difference in the eyes of the embassy? Thank you.
I think everything makes a difference, and you have to prepare as much documentation as you can to get that B2 visa because, B2 visas are often rejected. So, by showing that you have travel insurance, it shows that you will not be a burden on the systems in the US. So, they're more likely to give you a visa if they see that, you're not going to be burdening the US economy. If you get sick and then, go to an emergency room there.
All right. Let's move ahead to our next question that we got from Facebook. I'll be traveling for H1B stamping to India. I'm working for ex employer but switching jobs and have my I-797 with the new employer. I would start with the new employer after coming back to the US. Would there be any issues? Also, should my DS-160 reflect the new employer as a current employer?
I'm traveling for H1 stamping to India, working for X, but switching jobs and have so so if you're traveling for stamping, then you obviously have to go with the employer that you want to work with. Unless you don't plan to work with that new employer as soon as you come into the country. You first plan to work with X, then after a while change to the new employer. But if you're planning to work with the new employer as soon as you come back, then you need to definitely go for a visa with the new employer and show the new I-797 when you're entering into the US.
All right. Thank you, Prashanti, for putting those answers. And let's move ahead with our next viewer's question. And this is a bit long. Uh, Hi, all. Could you please advise me on this situation? My H1B extension was filed on February 7th under regular processing. My perm date is November 30th, 2023, and I expect to receive approval soon. My current H1B is set to expire in May 2025. I'm debating whether to upgrade my H1B to premium processing since my company is not covering the cost. I assume they will also not OPT for premium processing, opt for premium processing for the I-140. Since I need to apply for an H4 EAD, I'm considering paying out of pocket for premium processing for my I-140. However, I'm unsure if upgrading my H1B is worth the expense or if it's better to wait. My main concern is ensuring that this does not delay the H4 EAD timeline. Yeah, Prashanti.
Well, there's a lot of information in there, but the question is very simple whether to do H1B premium processing or not. That is, of course, an individual choice. You have your H1B is expiring in May, so March, April, May. That's 3 months. I would say go for premium processing because if you don't, then I don't know when you actually filed. You filed it in February, so only recently. I don't think
Yeah.
you'll get. Uh, you'll get a response by May, because that's only 3 months away. So, and then you might see that your I-94 is expired, and then if something happens, then you will be left without status. So, in order to avoid that kind of a situation, I think you should go with premium processing, if you
Mhm.
don't hear from them soon. And I don't think regular processing, you'll hear from them before 4 to 6 months. So, yeah, premium processing is the way to go.
All right. I think our viewer, we don't know your name, but do let us know your name and go ahead with the premium processing. Let's move ahead with the next question that we got from our viewer. And it's about change of passports in middle of 221G process. Hello, my H1B petition was under 221G for last 6 months, and yesterday they asked to submit the passport here in India. It still shows refused as of now, but another concern is my current passport is within 6 months of expiration. I have already applied for a new one. I don't know if I can update my DS 160. Shall I take both my passports and explain them my situation?
Yes, that's a good idea. Take, if you have a new passport as well, then you should submit the old passport and the new passport as well, showing that you received the extension. That's a good idea, because if your passport is expiring within 6 months, then they may want to see that new passport.
That's right. Okay, I think he got his answer. And with this, let's move ahead with the next one. Hello, I am on my fifth year of H1B through employer who is CAP exempt. I have my master's degree and work as a research assistant in psychology. I'm trying to see what my options are since my employer is not willing to sponsor because they only sponsor tenured professors. Any suggestion on what can I do? Trying to get into a PhD, would there be any paths there? Any help would be appreciated. Yeah.
So he's on his fifth year of the H1, which is CAP exempt, has a master's degree, working as a research assistant. Uh, if they're not willing to sponsor for the green card, then you are running out of options, because your H1 will only be for 6 years. Then
Mhm.
yeah, you'd have to either change status, like you said, to an F1, and update your skills, and perhaps go into the academic field. Maybe then you'll qualify for an AB1, or find an employer who's willing to sponsor you, um, you know,
Mhm.
for the green card. So that's the only two options you have: either change your status or find an employer quickly who's willing to sponsor you for a green card.
All right. So I think these two options are
I
the
mean, you
only.
could try to file for a change of status to an O1 if you qualify, based on your research. But, you know, I think it's important to file a green card at some point. And so if your present employer is not willing to do that, it's time to look for a new job.
Absolutely. Okay, I think this is a very understandable answer that we got from Prashanti. Thank you, Prashanti, for taking these questions. And I think these were the questions that we got from Facebook. With that, I would continue with my questions that I prepared from my end because we have already taken a lots of questions from our viewers. So let's also talk about the premium processing timelines and that have faced delays recently. So, should employers expect any slowdown in H1B adjudication for fiscal year 2025?
Well, if the present administration is hell bent on kind of slowing down the H-1B process, then the best way for them to do it is would be by slowing down their processing times, which is what they did during the last Trump administration. The processing times really skyrocketed for
Mm-hmm.
a lot of cases. With premium processing, they are mandated to process within 30 days, but right now they don't even take 30 days. I mean, usually if you do premium processing, the case gets approved within a week. So if they want to delay premium processing, then they can certainly delay it by either sending out RFEs, which will automatically delay the process, because then there's no 30-day mandate,
Mm-hmm.
or they can wait for the 29th day and process it on the 30th day, thereby delaying premium processing, which was now taking about a week or 2 weeks to, using the full 30 days to, process the case.
All right. Okay. And with that, I have another question regarding RFEs issued. So, with more RFEs issued for third party worksite placements, what proactive measures should consulting firms take to strengthen their petitions?
Um, so right now, as the H-1B regulation, new H-1B regulation has stated, USCIS will be looking to see if there's a bona fide job offer and there's bona fide specialty occupation work available for your employees. So if you happen to be a consulting company, then that would mean having to submit proof that the person will be consulted out to a third party worksite. And the proof would usually be a master services agreement, a purchase order, work order, letter from a vendor or a client. Those are the kind of documents that they're looking at. So if you don't have a job, then you should not be filing the H1. Only file the H1 if you do have a job available for that employee of yours. And this is consistent with what was being done in the previous years. Only recently, companies are filing H1s without POs and work orders, etc. But um, this has always been the case where they've needed it, for many years. So it's coming back to, square one where we're again submitting contracts and work orders. The only difference is they're not requiring you to submit contracts and work orders between all the parties involved, number one. They're just seeing if there's some bona fide employment available, and if they are happy that if they are satisfied that the letter from a vendor or a PO from the vendor shows bona fide job availability, then they may not ask for letter from the client, contract between the vendor and the client, contract between all the parties. But they can certainly start doing that if they want to, because they can interpret it any way they want. But in the actual comments to the regulation, they said that they're not looking for that. So let's see if that changes. But as of now, yeah, what we're asking clients to submit is at least something, vendor letter or a PO, even if it's from the vendor, to show bona fide employment. Also, one thing I forgot to mention, that with reference to specialty occupation, they want to see that it is a specialty occupation based on the end client requirements. If you are a consulting company, not based on your requirements. So in that case, if there is a question about specialty occupation, if you are using a job title which might prompt an RFE asking whether it's a specialty occupation or not, you'll have to submit a letter from the end client saying that the job requires a bachelor's degree in computer science, for example. Or maybe advertisements from the client website, when they advertised for that position, that the requirement was a bachelor's degree in computer science. So that's another thing to keep in mind, where an end client letter might be needed, or other information from the end client might be needed as to show that it's a specialty occupation position.
All right. Okay. And also another question, Prashanthi, that I would like to know it from you regarding what are the major takeaways from last year's H-1B Cap season that employers and applicants should learn from to improve their chances in fiscal year 2025?
Well, we noticed last year and the year before that they're asking for evaluations for, even if you have a foreign degree, even if it's like a basic computer science engineering degree, straightforward, they're still asking for evaluation. So I would prepare in advance, because if you prepare in the last minute, it's difficult to get evaluations from the evaluation companies. So as soon as you get picked, I would at least get the evaluations done for all the cases that you have,
Yeah.
so that you're sending them out with evaluations. Otherwise, by getting RFEs, just for evaluations, and that delays the case, increases the cost of the case. It makes no sense, and also increases the chances of denial. So evaluations are a must, and in order to do that, you need to prepare well in advance so that you can get the evaluation in advance. So you can't file the case in the last month, because in the last month of June, which is the last month to file, nobody's going to give you an evaluation. So keep that ready.
Yeah.
And the other change is, of course, we've seen changes from last year to this year. Last year, we didn't really submit vendor letters or client letters or contracts. This year, I think you need to get those ready and submit that with your application to avoid an RFE. So that's the other major change that I see. Um, and with reference to specialty occupation, use job titles if possible that are recognizable as specialty occupations, which USCIS is comfortable with, rather than using job titles that they're not comfortable with. Even though it's the job description that is important, not the title, the first thing that they look at is the title, and then they look at the job description. So that, and which leads me to the job description, which makes sure that the job description is detailed, the job description shows sufficient complexity,
Mm-hmm.
and sufficient um, details to show that a bachelor's degree is required in computer science or in any other specific field to show that it's a specialty occupation. So these are a few pointers that I have for this year.
All right, that's great. Okay, so friends, I can see more viewers have joined us right now, and let me take Pratap's comment here. So, thank you, Pratap, for being here and participating in this webinar. He's asking, I went to the US with H1B visa on September 4. After that, the project went on hold, and I came back to India on November 24. I was in US 50 days only, but did not run the payroll. Will they ask pay stubs at immigration? What are the mandatory documents should I carry with me?
Carry for what? Are you going for a visa or um, went to went to the US with you already have a visa? Are you returning back into the country? What is the context here? What are you planning to do next?
Yeah, I think Pratap, we are lacking some information. So please let us know what is the context here, so that Prashanti can help you out regarding your question. And we are here for, okay, it's almost time, but don't worry. We are here for 5 more minutes. So please post your question as soon as possible before the live show ends. And Prashanti, I have one more question for you about the Department of Labor has updated wage level data. So, how do these new prevailing wage figures impact the H-1B salary compliance and petition approvals?
Let's take Pratap's question first. I think he's answered it, and then because this is a little long, so let's take Pratap's
Sure,
question first. Sam,
sure. Why not? I think he said that I'm planning to go to US now.
if he's planning to travel to the US now, are you planning to travel with the same employer, or you're filing with another employer? If you're going with the same employer, then it's definitely going to be questionable as to what you did in the US for 50 days. Because that is pretty much shows that you're out of status unless um, you should have applied for a social security number and uh, gotten onto the payroll in that 50 days, or at least after you got the social security number, even if you came back, they should have given you back wages. So if you're planning to travel now, they're definitely going to ask you what your status was when you were in the US. So that payroll is important,
Yeah.
so that you don't get into trouble at the port of entry.
Okay. So I think Pratap, you got your answer, and thank you so much for participating here and for asking this question. I think Prashanti, let's end our session with the question that I have, mentioned. This one, the Department of Labor has updated wage level data. So how do these new prevailing wage figures impact H-1B salary compliance and petition approvals?
So yes, they have updated the wages and they continue to update them every year. So every year they update wages and they increase a little bit. Um, But the important thing is, another important thing they did is last year in July, they switched from one system to another. So they decommissioned the FLCA data center and they switched to the flag system. So this has improved the way we search for wages, because now we can search for wages based on the ONET code and not based on SOC code. What this means is that there are many more positions opened up for us where we can search for the wages. Before, the positions were not there, and we had to basically look for the closest position available and use that position. So now a lot more positions have opened up because they're using ONET directly, and ONET has many more positions in their database. But with reference to increase in the wage levels, we've seen uh, increases. Uh, some changes that I wanted to point out, which
Mhm.
were unusual, is that, for example, software developers, the wage level went up by 21% in San Francisco, whereas in New York it just went up by 12%. That's something to that I wanted to highlight. But otherwise, if I look at some common job titles, for example, software developer job title, for level two, it's 123,000, and that's gone up from 2023, where it was actually, let me check. The wage levels for 2023 to 2024, it's gone up again by a few thousand. If I look at the hourly rate for level 1 and level 2 and level 3, and comparing the different years, for 2023, it was $40 an hour, and now it's become $45 an hour. So you see it went up by $5 an hour. And in 2024, last year it was 42. So it went up by $3. So every year it goes up by $2 or $3 an hour, a few $1,000s a
Mhm.
year. And the same thing happened this year as well. Um, so yeah, wage levels have been continuously going up. In some instances, it hasn't gone up, but that's unusual. Um, but usually it does go up. For managers, for example, it's been steady for all the users. In fact, it went down in 2023 and then went up slightly again in 2024. But in the IT positions, usually it goes up marginally or to a great extent, um, by 10, 20,000 every year. So overall increase, 2% increase in H-1B jobs for all data, uh, in the for data for all data on all cases. Sorry, um, for example, data analyst cases, it went up by 19%. And as I said, software developer went up by 20%. So as you see, there has been an increase overall in the prevailing wages over the years, and you can expect that to continue.
All right. Thank you so much, Prashanti, for taking that question up and explaining us in a very detailed way. I'm sure our viewers are really, getting a lot of new information about this topic. And with that, it's almost time. We have I come across 1 hour, and we didn't even realize. So thank you so much, Prashanti, for being here. Any last message that you would like to share with our viewers?
Just that with the prevailing wages increasing every year, and I don't know how realistic that wage increase is, whether it is actually mirroring the actual wages that people are getting paid. People who are not on a H1 are getting paid. It should, but I don't think it is. I think the prevailing wages for H1 candidates are more than the wages that are usually being given in the market for non H1B candidates. So this, puts employers at a distinctly disadvantageous position, and they will, obviously hire less H1B workers, and then what will happen is then the work, if there are no US citizens, permanent residents available for this job, the work, all these jobs will go out of the country. So
Yes.
I don't think what the present administration is saying is true, that uh, the jobs are not available for US citizens. I don't think there are enough permanent residents and US citizens available for these kind of senior IT position jobs. Maybe for entry level positions, they might be available given the year, because every year is different. But for senior positions, there's definitely still a dearth in talent in the US. So if they don't allow H1Bs to um, kind of make up for that dearth, then all these positions will go outside the country, and Microsofts and Amazons will hire people in India or in Mexico or Costa Rica, and then the economy of those countries will benefit as opposed to the US.
Absolutely. I think that's wonderfully explained and, putting up, I would say, such a different information to us also. I am sure our viewers are learning a lot of things from this webinar. And before starting the show, I asked a question that are they fully prepared for the H1B lottery 2025 or not? But I said that after the show, they are definitely going to be. At least they will have, more knowledge, they will have more data, how to prepare, they'll get the way. So I'm sure, Prashanti, with your insights, with your expertise, they have filled themselves with lots of information. So again, I would say it was really wonderful having show with you. I really enjoyed that. Thank you so much for being here, and I'm really looking forward to have more shows with you.
Thank you, Sam. Take care.
All right, that's great. Friends, the great thing is that you can also contact Attorney Prashanthi Reddy on the given number. That is 212-354-1010. And the email ID is prashanthi at reddyesq.com. And visit our website, that is www.reddyesq.com. And with that, friends, I would like to take a leave now. Don't forget to like, share, and subscribe to Immigration Talk Show. Our handle is at Immigration Talk Show, and we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So follow us on these many platforms and ask as many questions as possible regarding your immigration journey. We come up here with very different topics on every week so that you guys can get a clear concept about your problems. So keep watching Immigration Talk Show. Meanwhile, I'm Sam signing off for now. Goodbye, everyone, and take care.